case number 115604, State of Kansas v. Butler.
Mr. Chief Justice, and may it please the court, my name is Kai Mann. I am here from the Appellate Defender's Office on behalf of the appellant, Mr. Butler, and may I please reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. As far as a brief factual overview, Mr. Butler was convicted of 1 count each of first-degree murder, of felony first-degree murder, of conspiracy to commit aggravated robbery and an attempted aggravated robbery, all stemming from events that allegedly occurred on January 9th, 2013. Mr. Butler had a co-defendant in this case, Mr. Jewell, who ended up pleading with the state in exchange for cooperation at trial, at which he implicated Mr. Butler in the events on January 9th, which the evidence at trial suggested was a robbery motivated by Mr. Butler being unhappy with some prior marijuana deals with a Mr. Llanos, who he met through his co-workers, Mr. Cole and Mr. Barger. And on January 9th, 2013, Mr. Butler and Mr. Jewell went to Mr. Llanos' apartment after being apprised that he was there by Mr. Cole, at which point Mr. Butler went up to the room where other people were, shots occurred, and a Mr. Gibson was killed in the altercation. At trial, Mr. Butler was convicted, and we have raised 7 issues on appeal. The 7th issue is a sentencing issue. Just going to submit that on the briefs. Post-release v. parole, I believe the state conceded that resentencing needs to occur to do that. But as far as issue 1, related to the insufficiency of the evidence supporting the alternative overt acts of conspiracy, when Mr. Butler was charged with his conspiracy to commit aggravated robbery, the complaint alleged 3 overt acts. 1, discussing and planning the robbery. 2, arriving at the location of the robbery. And 3, actually carrying out the plan.
Were they joined by the conjunction "and" in the charge, like they were in the instruction?
You know, I can't recall off the top of my head, but I do have a copy of the charge. It says, and in furtherance of such agreement, committed the following overt act, to wit, discussed and planned robbing Nick Llanos and the roles of each person, then arrived at the location discussed and carried out the plan in violation of KSA.
So listed as a series of behaviors, not really as alternatives to one another. Same in the instruction. I think that's what you just read to me. That's what the instruction reads.
I read the complaint, and I have the instruction.
Take my word for it.
Yeah.
Okay, assuming for purposes of argument,
That's what it says.
"and" appears in both places. How does that affect your argument? I mean, the jury wasn't really told you can view these as alternatives at all. The jury was told this is a series of behaviors that together make up the overt act.
And I understand, and I think that perhaps, by the fact that I was confused by that for a minute here might lead to the fact that I'm not sure if a reasonable juror would view those series of events as one event, because, the planning and preparation, arriving at the location, and carrying out the plan all occur, unless this is just one big go, meet up, let's do this, they all occur at different discrete times. Mr. Butler, the evidence showed, had been discussing robbing Mr. Llanos for at least a month prior to this, and attempting to enlist the help of his coworkers. And so I don't think that even if it was specifically and discreetly charged that way, I don't think that a jury would view those three elements of an alleged overt act as one overt act, as opposed to three overt acts. And I still think we end up in the same position of being completely unsure as to whether or not Mr. Butler was convicted on conspiracy for merely discussing and planning, or if the jury took it all together.
Before we even get to
Yes.
that question, don't we have to know one way or the other whether or not conspiracy is, whether or not we even have an alternative means situation?
Yes, that would be true.
So explain to me how the statute creates alternative means for committing conspiracy.
Well, the statute doesn't commit alternative means for committing.
And isn't that what we've said, that's where our analysis starts?
Yes.
Starts with the language of the statute.
It starts with the language of the statute, but I think that since an overt act can necessarily be anything that is close to showing consummation of the crime.
Different
Yeah.
factual scenarios can prove
Yes.
an overt act.
Right.
But our recent case law has tended at least to describe those as options within the means, has it not?
It has. I know that we cited to Enriquez at the Court of Appeals, and I also know, but I think that is one way to look at it. However, I think since we're dealing with a single element that's difficult to define and does have a factual component, I do think once you get to the point to where you're alleging multiple different things that could fit within an overt act, then even if the statute doesn't create it by its plain language, by the way it's presented to a jury, an alternative means problem can arise requiring unanimity to make sure that the exact overt act was agreed on by all 12 jurors. So while not specifically created by the statute, I believe that the way these cases can be presented to a jury inherently create alternative means issues as long as the state does not elect on a particular mean with which to instruct the jury on and
If
proceed
we
on.
accept that, and I think there's some skepticism, but if we accept that this somehow created an alternative means situation, then it isn't a matter of the jury having to be unanimous on the means. In fact, we said the opposite, haven't we? We've said the jury doesn't have to be unanimous on the means. They just need to have adequate proof of each of the means, right?
And that is true. However, if mere discussing and planning is one of the means, and that does not rise as a matter of
As a
law
matter of law to an overt
to an
act.
overt act, then there can never be sufficient evidence on all three means at that point. So that is the distinction at this case, is that one of the means that we are alleging was mere preparation, which cannot complete a full conspiracy.
So it sounds to me like your argument is less of an alternative means sufficiency argument and more of a jury instruction argument, that the instruction misstated the law or was legally erroneous.
I think that could be an alternative way to raise the issue.
Well, and it might make a difference for our standard of review.
Yeah, I understand. And I think that I think that given the state laid out within its complaint these three acts making either one discrete overt act or three different overt acts that the jury could then pick from, I think that brings it into a sufficiency as opposed to a jury instruction issue, although it certainly could be raised as a jury instruction issue. I think that's one of those things that you could raise twice depending on exactly how you want to attack it, or at least I would try at some point.
But if it had been in the complaint, but planning and discussing was not included in the jury instruction, I mean, that happens all the time with the evidence, where the jury instruction comports with the law, but the complaint doesn't.
Right.
Then you wouldn't have that argument.
No, would because at that point the state would have elected.
And so that tells me that the culprit here is the jury instruction.
Okay.
You understand what I'm
No,
saying? to
yeah,
you?
yes, I understand what you're saying, and I think, I think that ultimately, it's an error at some point, but whether or not it's, classically a sufficiency error or, more classically within a jury instruction error. I think that at the end of the day, the jury was given multiple options as far as of an overt act, but no attempt and consideration was given to make sure that the same act was on. However, since we are discussing jury instructions, I would like to move on to issue 2, and if that is okay.
I'd
What would
love
our
for you to move on to issue 2. Go ahead. Do you have
If it
something
isn't,
else?
if it is a jury instruction on this first issue, what would our standard of review be?
Your standard of review, I would believe, and I will double check the record. I do not believe that is requested a different instruction. So if it was not requested, it would be clearly erroneous. But I will double check that just to make sure, because I had not anticipated discussing that as a jury question issue. But as far as jury instruction issue, also on the conspiracy to commit aggravated robbery, the jury was only instructed that the crime, or that the defendant must commit the crime of conspiracy to aggravated robbery as knowingly. It is our position that this is a specific intent crime, as laid out by the elements within the jury instructions.
It actually kind of got mixed messages, didn't it? That's why I'm eager to move on to
Yes.
this issue. Because instruction number 19 said that it also dealt with conspiracy,
It did.
and its subparagraph 2 said the defendant did agree with his co-conspirator with the intent that the aggravated robbery be committed. So the jury was informed that there had to be an intention to commit the aggravated robbery. You're just saying that the
They were
second intention of conspiracy knowingly is insufficient.
Yes,
Right.
and they were also never instructed on the definition of intentional and intent, which is above knowingly, and given that the element instruction of conspiracy involves an intent an intent to commit the underlying crime, I don't know if anybody could knowingly agree to something to do intentionally. I think at that point, I don't know how. I don't know how you could knowingly agree to do something intentionally without intentionally agreeing to do it.
Well, if that's true, then what's wrong with the instructions?
Is that knowingly represents a lower mens rea,
Right.
and therefore it doesn't impart the full culpability, the full mens rea to the jury that they must decide which is an element of the crime.
Does the conspiracy statute list a mental state?
It does not. I believe the conspiracy statute lists that the agreement must be done with the intent, or the agreement must be formed with the intent to commit the underlying crime, or whatever the conspiratorial crime is. But it does not say, intentionally enter into an agreement to commit. But I think that, again, if you are entering into an agreement to intend to commit a crime, that is the same thing as
What do we do with our statute that effectively says where a criminal statute does not list a specific mental state, knowingly is sufficient?
But I'm not exactly sure if that's true, because there is intent to the element of wanting to commit the underlying crime. So I'm not exactly sure that there's no mental state. There is a mental state leading to that specific element. And also, the proof of a higher mental state proves all the lower mental states. So to lessen confusion, and intentional instruction would have been far more appropriate here than the knowingly instruction to the jury, and prevented confusion in the first place. And so therefore, the intent is used within the crime. The intent must be to commit the underlying crime that is agreed upon, but without the jury was never disclosed to that. And I see that I'm out of time.
But why, given the aggravated robbery intent, is this not harmless error? If the jury had to conclude that
Right.
it was intentionally.
Because they were never given a definition of intentionally, so I don't know if the jury could ever fully appreciate whether or not an agreement was fully ever entered into with the requisite mental state required to sustain a conviction. And so I think that it'd be between that and the insufficient evidence as to the overt acts, along with the other errors. I think, even if standing alone, isn't clear error. Once the other errors are considered together, I think under cumulative error analysis that these together would produce prejudice.
But our harmless standard is clearly erroneous.
Yes.
So why should we be firmly convinced that the jury would have acquitted if this instruction had said intentionally instead of knowingly? What is there that would firmly convince me that changing that word would have resulted in an acquittal here?
Well, I mean, I think, there was the evidence of Mr. Cole that he did not want to participate in this conspiracy because he was friends with Mr. Llanos, but then he ended up texting him. I think that the way this conspiracy came together, I don't think it was ever clear outside of maybe Mr. Jewell, if a fully formed conspiracy was ever launched, or if this was more of an ad hoc robbery gone wrong and admitted to the day, or yet agreed to relatively soon before the robbery happened, when Mr. Jewell agreed to do this robbery on January 9th. But again, even if not standing alone, I still do think that especially when considered with the error in issue 1, and lack of limiting instruction, I think that there's, if not clear error, there is reversible error cumulatively. Excuse me.
Any more questions?
If I may, I have
Yes.
a couple follow-ups probably. Your argument is that the instruction on knowingly was a misstatement of the law.
Yes.
It's not legally appropriate, right?
Right.
And I'm trying to figure out what you would point this court to lead us to that conclusion. And I've heard you say that you point us to the statute on conspiracy, which you've said includes an element of intent, or includes the word intent. If that's not the case,
Yeah.
can you point us to anything else?
I will. Well, first I will check to make sure that is the case. I mean, I think the language of the instruction itself, the jury was instructed that the defendant did so agree with the intent that the aggravated robbery be committed. So I don't know. Again, I think that shows that there must be an intent here, because again, I
Well,
don't.
that instruction might be wrong,
Right.
but the instruction can't give content to the law.
No,
I mean,
it-
what is
right.
what is the mental state for conspiracy? That's the question.
I fully believe that it is, that it is a specific intent crime, that you enter into agreement
but
with the intent.
whether it's specific intent or not doesn't answer the question of what is the proper culpable mental state.
Well,
And so, what can you point us to that would indicate that knowingly is the wrong culpable mental state to assign to the crime of conspiracy in Kansas?
I mean, again, and unless I am mistaken, if there is an intent element associated, or if there is an intent associated with an element, then that intent has to be proven for that element. And furthermore, given that the only elements of conspiracy are agreement and overt act, if you intend to commit a crime during an agreement, I don't know how else a knowingly could get in there. I guess as far as logically in my own head, I don't see.
How else that knowingly could get in there?
Yeah, because if I have to, in order to engage into a conspiracy, if
You
I
can't-
have to agree.
Let me stop you
Yeah.
for just a second, if
Yeah.
you don't mind. I'm just trying to make sense of
Yeah.
what you just said. You can't agree without knowing you agree, can you?
That
I mean,
is-
that's just an impossibility.
That is true, but can I knowingly agree to something, to intend to do something without intending to enter that agreement? I guess what I'm saying is I don't know how I can knowingly agree to a conspiracy to intend to commit a crime without intending to. That's where I'm going, because the agreement itself.
And that alone, you think it's just a logical.
I do.
Fallacy,
I
and
really
that's-
do. I think it would be incredibly difficult, if not impossible, to agree to a conspiracy, but not intend to conspire to intend to commit the underlying crime.
Well, I don't think that's what happened here, though. They got instructed that that the agreement had to be knowing,
Right.
But there also had to be an intention to commit the underlying offense.
Yes, but again, I think that, and I'm doing a very poor job of explaining this, but if you have to agree to intend the underlying felony, and so you have to agree, or so you have to intend to commit that felony.
Mm-hmm.
I don't know if I can just knowingly
Agree? You think it has to
Agree.
be an intention to agree?
I think so, or
Other than
else,
that, do you have anything else to give to my colleague who
no,
asked you
I do
for
not.
something
Um,
supporting it?
unless I forgot the question.
That's fine, thank you.
Okay, thank you.
Any further questions? Thank you,
Thank
Counselor.
you.
May it please the court. Christopher Schneider, Assistant Wyandotte County District Attorney, on behalf of the appellee, the state of Kansas. And as a preliminary matter, I would agree that as far as issue number 7, the sentencing issue, the question of lifetime post-release versus lifetime parole, that the case needs to be remanded for resentencing to correct that issue. As for the conviction, it's the state's position that the district court should be affirmed, that the conviction should stand. As to the sufficiency of the evidence for the crime of a conspiracy to commit aggravated robbery, and again, the challenge is not to the other two counts, but as to the conspiracy to commit aggravated robbery, if you look at all the evidence in the light most favorable to the state, to determine if a rational fact finder could find the defendant guilty, I think the answer to that is yes, a rational fact finder could.
But if a rational jury could find that he planned and discussed, that legally that wouldn't be a overt act, would it?
If the planning and if all it is planning and discussion, then that's correct, and I noted that in the brief. If the only thing that was proven was planning and discussing, then no, you don't have the overt act. And it's clear you have to have that. You have to have the agreement, the planning and discussing, the agreement.
The argument is, why is that part of the instruction with regard to overt act? Because the act was going to the location and committing the crime.
Right.
Because that's what happened after the planning and discussion.
But logically, to get to that point, it has to be, for a conspiracy, it has to be planned. There has to be an agreement to do that. So
That's the essence
Element
of the
number one.
crime, is
Right.
the agreement. But the agreement doesn't get you there. You have to then have something in furtherance of the agreement.
Right.
And when you say the act in furtherance of the agreement is the agreement, then that's confusing.
Well, no, because you're actually saying it's more than that, because you're saying that yes, it's the agreement, but you're also saying they went to the location and they attempted and they went to carry out an aggravated robbery, and they did that. They didn't succeed in the robbery. They ended up killing somebody in the process. But it's all of those things together. It's the whole conglomeration. And that's what. And
So
that's
is it the state's position that the only thing that saves this instruction from being legally erroneous is the conjunction "and" between those three?
I'm not sure if that's
Acts.
the only thing, but I think it sure helps.
Well, let me rephrase the question. If the instruction, hypothetically, this isn't the instruction we have, but if the instruction had said planning and discussing, or driving to the location, or committing the robbery, would that be a correct statement of the law? Would that be legally appropriate?
One, it wouldn't be legally appropriate. Two, it wouldn't be a correct statement of the law.
Okay,
three,
and the reason is-
three, I think that might be reversible error.
Well, the reason is because, as Justice Johnson just pointed out, you don't have planning and discussing isn't sufficient by itself. to be an overt act. So is that enough to save this instruction, I guess, the difference between and or? Or does it create needless and unnecessary confusion in the minds of the jury?
I think it is sufficient. First of all, I think it is sufficient. Secondly, I don't think it creates mindless confusion because you've already told them they have to find that agreement, the planning and discussing. You've already told them they have to find that. So it's basically redundant, if anything.
But that redundancy, again, if just the changing, and we've already established just the changing of and or could move this instruction into error territory.
Correct.
And so just make your best argument to me why that's not confusing. That unnecessary redundancy does seem to me to lead potentially to confusion in the minds of the jury.
I think you, and with all due respect, I think you may be faulting our jurors to some extent because I think what we're telling them is you have to find all of these things, and all of them,
That's
and
not
they have to find all of those things for the conspiracy to be there, albeit the agreement is a separate line of that instruction, separate.
And then it repeats the agreement in the overt act
And then we're
instruction.
saying again that there has to be this agreement, but we're not just saying there just has to be this agreement or something or something. There has to be this, there has to be the going to the location, and there has to be the effort to carry out.
You're just saying no reasonable juror would be confused into thinking that the agreement itself can be an overt act.
Correct. So even if the instruction is erroneous, the error is harmless because it's certainly not clear error. It's certainly not when you look at the totality. Even if the wording is not what you as judges, we as lawyers think it should be, the end result's not going to be different. It's not the error is harmless. And I think it's important to keep in mind too that with the conspiracy, it's not a conspiracy is not an instantaneous, or at least oftentimes it's not an instantaneous crime. It takes place over time, as it did in this case, with Mr. Butler being dissatisfied with his purchase of marijuana from Mr. Llanos and stewing about it and wanting to do something about it, discussing the matter and recruiting co-conspirators. And finally, he and Mr. Jewell agree this is what they're going to do, and they take the necessary steps to carry it out.
Excuse me, counsel, are you now explaining why this error is harmless, or what is your underlying point?
Well, I think the point is, counsel argued that some of the discussion started some time before, a matter of weeks before the actual events on January 9th, 2013. And what I'm saying is that's normal for a conspiracy. That this isn't an instantaneous. It's not something that necessarily has to happen instantaneously or bang 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 one right after the other. It can congeal over time, and that's what we have here. That's my point. Is that it sort of congeals over time. And then moving on, the district court did correctly instruct the jury on the crime of conspiracy to commit aggravated robbery. There was no objection to the instruction. The conspiracy statute itself, as was discussed, doesn't specify a required culpable mental state in general. It does say that there has to be intent to commit the underlying crime, which in this case was aggravated robbery. But it doesn't specify that the defendant has to knowingly or intentionally or recklessly. So the statute, the legislature has said where a statute doesn't specify which culpable mental state, any of the three will suffice. And the court chose to instruct the jury as with the mental state of knowingly. And it was a correct instruction. There was no objection to that. It's not clearly erroneous because there had to be a knowing agreement, which the evidence showed there was, but it also had to be the intent to commit that robbery, and that's what the defendant and his co-defendant intended to do. They went to the residence at 83rd and Monroe, and they went there to commit an aggravated robbery. Unfortunately, it went really bad. So the district court did correctly instruct the jury, and given that the district court's rulings were not erroneous, there cannot be cumulative error. So I would ask the court to affirm the decision of the district court on those matters.
I have a question about a different issue.
Yes, Your Honor.
On the way to forming this conspiracy, as you allege, there were other crimes elicited: sale of marijuana, threats towards Cole and Barger, threats and regarding the potential robbery of Llanos. Defendant alleges that those would require some limiting instructions. Why don't they require some limiting instructions? They're prior crimes or civil wrongs and talking about criminal activity. Why wasn't a limiting instruction appropriate on some of this conduct?
Well, because it's all part and parcel of the crime of conspiracy. The discussions as to the prior marijuana transactions between Llanos and Butler, that's what gave rise to the conspiracy. If it wasn't but for those, there wouldn't be there.
So if there's evidence deduced that it's part of the conspiracy, then there's kind of carte blanche allows for any kind of evidence requiring other criminal activity.
Well, no, it's not carte blanche. I think it has to relate to the conspiracy or to the underlying crimes, but I don't think it's carte blanche. It certainly has to be relevant and has to relate.
Okay.
And I think in this case, all of those things did.
Do you have any further presentation?
I have no further presentation. Unless there are further questions from the court, I would ask that the decision of the district court be affirmed.
I was just going to ask about the prosecutorial error issue, just so we can hear your side of it, particularly on harmlessness, if we were to decide there was error.
First of all, it's not. First of all, it's not error, and secondly, if it is error, it's harmless. The counsel on rebuttal responded to defense counsel in his closing argument, alleged that the state's theory of the case was ridiculous. And the prosecutor on rebuttal attempted to rebut that and basically said, first of all, our case isn't ridiculous. The only use of the word ridiculous by the prosecutor was in response to the challenge to the state, the challenge by defense counsel that the state's case was ridiculous, that the state's theory was ridiculous. And that's what it's centered around, is refuting that there was nothing ridiculous about the state's theory of the case. The prosecutor did not impugn the defendant. He didn't impugn defense counsel or any witnesses or anyone else, or make light of defendant's argument. He just basically said, responded to the allegation that the state's arguments are ridiculous. And he said, no, they're not, and here's why they're not ridiculous. And he ended with a rhetorical question. So I would argue, first of all, that's not error. And if for some reason that it would be found to be error, if you look at the context, look at the whole context of it, it's harmless.
Was it fair comment by defense counsel to call the state's case or theory ridiculous?
Well, if defense counsel is going to be held to the same standard as we as prosecutors are, then no, it's not fair. But it happened.
Well, I know it happened, but my question is, with putting aside the standards that we hold prosecutors to, is it fair comment by defense counsel?
No.
And your response is, because it was not fair comment, it's okay for the prosecutor to respond in kind to an unfair comment?
No, Your Honor, because the prosecutor didn't respond in kind. The prosecutor didn't turn around and say, hey, defendant, your argument's ridiculous. That's not what the prosecutor did at all. The prosecutor basically said, here's why my argument, here's why the state's argument is not ridiculous.
Well, why isn't it fair comment for the defense attorney to say that? I mean, these are jury trials. You're arguing to a jury. Well, maybe it's wrong,
Well,
but why isn't it fair comment?
Well, because I think for it to be fair, and the Chief Justice and I kind of had this discussion just a minute ago. If I, as a prosecutor, stand in front of a jury and say, defendant's argument is ridiculous, I'm probably going to get called on that.
Well, you just told us that wasn't error.
In this case, well, but the prosecutor didn't do that. The prosecutor didn't say the defendant's argument was ridiculous. The prosecutor said the prosecutor said my argument is not ridiculous, and here's why my argument is not ridiculous.
That's how it started.
And then, as you said, there was a rhetorical question later about whether the defense argument, in fact, wasn't the ridiculous one.
I think
It's just kind of tit for tat. Once the defense lawyers said the state's theory was ridiculous, then the prosecutor did stand up and say, let me tell you the reasons why our theory isn't ridiculous. And by the way, their theory is X and ridiculous. You decide. I mean, it was back and forth.
If I could refresh everybody's recollection, maybe that's what you're referring to.
Yeah, page.
Prosecutor says, where is this 7 to 10 person conspiracy to point out one man, a man that some don't know, a man the rest don't have a problem with? Ladies and gentlemen, ridiculous. Sounds like the prosecutor, he or she is referring to the defense argument.
See, I didn't take it that way. I took it as a rhetorical question when I read it. But
Any more questions? Any further presentation? All right, thank you, counsel.
thank you.
May it please the court. Excuse me. Going back to issues to pick up from my first presentation, I did check. There was no objection to the jury instructions as stated. And as far as the mental state for conspiracy, I will submit that subsection A, defining the conspiracy's agreement between another person, does not list the mental state, but subsection B does state that it is immaterial to the criminal liability of a person charged with conspiracy that any other person with whom the defendant conspired lacked the actual intent to commit the underlying crime, provided that the defendant believed that the other person did have the actual intent to commit the underlying crime. So therefore, there has to be an actual intent underlying the crime, and therefore, and I think subsection C, when it discusses with withdrawing from a conspiracy, also again does not state, but implies and can be read to infer a larger degree of culpability if you have to voluntarily withdraw.
What do we do with our older case law, like Campbell, et cetera, that describes the intent required for a conspiracy to be willful and or knowing?
I think that that case law should be overruled in favor of intent, given the statute clearly states that that there must be an actual intent somewhere in the conspiracy to commit the underlying crime. And so therefore, a knowingly, just instructing the jury on knowingly doesn't give them the full picture of the intent for a crime that does involve intent to commit the underlying crime.
For
The
you-
problem, it seems to me, is that we're conflating two intents. Intent to agree with others and an intent to do the crime. And so I don't see why you couldn't have the general intent of knowingly with regard to the agreement, even though the specific intent for the underlying crime is included also. Is that making sense to you?
It does. You know, but I think, you know, that once, if you get to, well, I think, you know, that would bring us back to the 215202 culpable mental state section under subsection H. Person acts intentionally or with intent with respect to the nature of such person's conduct. And in conspiracy, the conduct is just the agreement to fulfill this crime. And if there has to be intent within the conspiracy to fulfill the crime, then I think if you enter into a conspiracy knowingly, then I would argue as to whether or not you've actually entered into a conspiracy if there's no intent to actually do the crime. And it kind of brings us back to what would be the proper level of culpability, because if it doesn't one, then under 215202E, one is required, but it also says that intent, knowledge, and recklessness suffices. And I don't think that there's an argument for one can recklessly enter into a conspiracy. And if there has to be intent for the underlying crime to be committed, then I think that intentional would be the appropriate mental state to instruct on.
Counsel, you're out of time,
Yes.
but before you sit down, without putting words in your mouth, you acknowledged you're basically swimming upstream on calling this harmless.
I think that's fair to say, yes.
All right. In response to the question Justice Johnson asked minutes ago, tell us your best argument why we should do what you want us to do on this particular conviction.
I do believe that conspiracy requires an intentional conduct of the defendant, and that knowingly is not enough to satisfy the elements of conspiracy. And on top of that, considering that the jury was misled, given the overt act issue, I don't think that there's a reasonable possibility that this was proven properly to a jury, and therefore I don't think that the state carried their burden of proof once these errors are taken into consideration.
I don't think you've
I'm
recited verbatim what our standard is. He was reciting it earlier.
Oh.
We have to be firmly convinced
Yes.
that the jury would have reached a different verdict, basically. You have anything to add
Oh, okay, yeah.
besides what you've said
Yeah,
so
yeah,
far?
yeah, excuse me, I misunderstood. That I mean, as far as I think that the jury probably relied on discussion and planning and convicting, just because that's the easiest one. It's the first one. That's one that definitely occurred. And again, I think that whether or not there was a fully formed intent to commit the conspiracy, I think that could come back different had the jury been properly instructed on the definition of intent. And again, I understand it's difficult to intuit what jurors would do had things changed, but I do believe that these errors prevented the jury from even having an opportunity to really make the correct choice, and therefore I do think this is reversible error. I do think that another jury, given the correct instructions, may come to a different result. I hesitate to say definitely because I don't know. I can't know that. But I do feel that these errors prevented the jury from having the opportunity.
Very well, thank you, counsel.
Thank you.
We appreciate the arguments of both counsel this morning. Court will take this matter under advisement. This time, the court is in recess for 15 minutes.